Welcome to the Spiggle Law Firm podcast, where we help people who've been fired or afraid they might be, and also talk about cutting edge issues in the news. I'm thrilled today to be joined by a senior attorney in our office, Louise Ryder, who is going to continue our discussion about the EEO process. But before we get back into that, just some of the usual legalese. This is not intended to create an attorney-client relationship with our firm, nor is this intended to be legal advice for your specific case. If you want those things, then you got it. You should go hire a lawyer. So with that said, Louise, let's jump back in. Just to recap, so we're going through the EEO process for federal sector workers. Last time we talked about what a federal sector worker is, so I think we're past that point, and we talked about the informal process with the EEO, going to the EEO officer, mediation, and some strategies around that. And so now we are, I believe, you're the expert, but to the formal stage. So I'll let you take it from here.
Thank you, Tom, for having me. It's a pleasure as always. So the stages, of course, after the informal stage, you are correct. It is the formal EEO stage. So you'll, at the end of the informal complaint or pre-complaint stage, you'll get a notice of right to file a formal complaint from the agency. And once you get that document, it will outline the deadlines, but you'll have 15 days to file a formal complaint. You'll basically want to go through and outline what your claims are. And I tend to think if you're proceeding pro se, generally the agency will expect more of a narrative format, but I tend to think that it's better if you can outline what the specific claims are in a format that's a little closer to the way the agency will formulate your claims. So first of all, it's important that you address each allegation that is a discrete act. And what that means is the law addresses claims of hostile work environment different from discrete acts of discrimination. A hostile work environment, the timeliness is from the most recent instance in which you were subjected to harassment. And it is a claim that encompasses a variety of and a large number of acts that may not rise to the level of discriminatory disparate treatment on their own, but together can form a hostile work environment. And so with regards to any discrete acts, you will want to make sure that you identify what those discrete acts are in your formal complaint. And what that means is a discrete act is something that generally will cause you monetary harm. So usually it's if you were suspended, if you were falsely charged as AWOL, absent without leave, and lost pay as a result, if you were terminated, of course. Some that can be expanded, and the EEOC does tend to take a slightly broader view in that you can include performance appraisals that are negative or even lowered. Whether that'll ultimately survive is another question that we can get to at a later date. But and especially though, if the performance appraisal caused you to have a smaller bonus, then it would definitely be covered as a discrete act. But sometimes even written warnings under certain circumstances, you can argue, are discrete acts as well. So you're going to want to make sure that you identify each event by date and by the person involved. It's always better to make sure you name the person who did something against you, the person who issued you a performance appraisal or suspension, because if it makes it much clearer going forward. So try to avoid passive voice if you can.
Quick question, Louise. Just the mechanics of it. So you've gone through the informal EEO process. You've either declined or mediation fell through. And then do you get an email? Is this a hard copy document? How do you get the notice that you've got the 15 days? What does that look like?
So oftentimes they'll ask if you're acceptable to, or if you're amenable to accepting it in an electronic format, and then they'll just email it to you. Generally, it is mailed out if you don't agree to service by email. But of course, some agencies, they'll even send you a link where you have to access their secure email services and download it from there. But generally, you should look for it in the mail.
And it's like a one pager. Like how big of a document are we talking about?
Yeah, it's usually a couple pages. And all it really says is that the processing of your informal complaint has been completed, that you were unable to resolve it through mediation or settlement, and that you have the right to file a formal EEO complaint against the agency. And it will generally have a point of contact as well, the person to whom you should email or file another way, otherwise address the formal complaint to. And you can send your formal complaint form to that person within the requisite time.
And then is there a particular format when you say a form? Do you get like, this is how we want it presented, or is it just a blue sky, pen to paper? Like what kind of format is it in?
So it will have sections. It'll ask for your name, your title, your grade level. It'll ask for the most recent date of discrimination, which you definitely want to include. And if you're including harassment, you want to make sure you include the most recent time you were harassed in any way related to your hostile work environment claim. And it'll ask the basis of discrimination, and that's a key one. So technically in the federal sector, you can raise additional bases of discrimination at a later date, as long as it's the same claims, but it's still better to try to include them all at the beginning. And so you'll want, if you think that you're being discriminated against based on your race or your sex, then you'll want to check those boxes off. There can be a misconception. Sometimes people can forget to add retaliation when they've made a reasonable accommodation request. So just be aware of that. If you're clicking off or checking off disability discrimination, if you have made a reasonable accommodation request and after that request has been made, you were subjected to additional harassment or discrimination, you should absolutely check off the retaliation box as well.
So I guess that would be one, obviously this process, you can use it without an attorney, as you said, pro se. But one advantage, I suppose, to having an attorney is you get, you get it set forth in a form that the agency is more likely to accept and the way they're going to analyze it. And you get someone who can help you flesh out like all those things that you need to include. You said for those folks who are going, proceeding without an attorney or proceeding pro se, with a more narrative format, you mean like you just tell a story, like this is what happened, best of times, the worst of times, all the way through?
Well, yeah, I mean, I've taken over a lot of cases after the formal complaint has already been filed. And so usually when I see those formal complaints that the client prepared on their own, they do tend to have a narrative format. And the form asks you to describe the discriminatory acts. So it does seem to solicit that. When I say, or when we say a claims format, it's usually will outline whether or not the individual has been discriminated against based on a specific basis, when, and then we'll outline exactly each claim. And one way in which having an attorney can definitely help is, especially with hostile work environment claims, I find that there are so many people who struggle with articulating ways in which they're being targeted or singled out or really treated differently, because most of the time we're used to making conclusions off of the way people treat us. It's just human nature to and so you'll say, oh, well, she really doesn't like us. Or if someone were to say that, what you need to do is dig down into, well, why do you think that? And is it the tone of her voice? Is it the way she ignores you in meetings? Is it the way she speaks to you? Is it the way that you're singled out with regards to work assignments? Are you given a higher volume of work assignments? Are you given more complicated work assignments? Are you assigned less prestigious work? There's a lot of different categories that sometimes having a lawyer can help pull out some of the language that would describe different things that that certain people might not be able to articulate.
Yeah, I think that's a good point. I mean, as attorneys, that's what we do, right? We help people frame stories in a certain way. I mean, when I mean story, not something made up, but it's sort of like carving a figure out of marble, right? You've got a bunch of material and you've got to whittle it down into something that looks like a form or a piece of art. And that's what attorneys do, except with words, is to help you kind of frame what happened. Because you're right. I mean, you don't have to be an attorney to do these things. Of course, there are a lot of people who can tell a good story and get all the facts out. But sometimes it's helpful just to have a third party kind of pull these things out and like really kind of help you drill down to get the kind of the granular, to get the real picture of what happened. Because I think as human beings, we just in our own mind tend to kind of assume people understand what we are saying, and they may not, because somebody's going through this, has lived through it. It's very important. There's a lot going on, and sometimes they can become blind to some of the details just because they've lived with it for so long, which is true of all of us.
Definitely. And also with those narratives, I find one piece of advice I would give to anyone is try to keep things in chronological order. It's not the way that we naturally think. We tend to think by category and groups of things, but generally when you're in a legal proceeding, it's always best to include things in chronological order because that's how a judge would want to see it.
Yeah, I think that's a good point. And let me ask you, and I'm sure it varies widely, but is there kind of a typical page number that you see? Are we talking 5 pages, 20 pages, more?
It really depends on the person. Usually what we'll do is we'll just say see attached because the form doesn't have that much space for you to provide your description. And then we'll have a page. I mean, usually it's just a page document outlining what those claims are because it's easy to get bogged down in all of the facts related to the claim. But at this stage, it's better just to say, this happened, not all the explanation, not all the context. We're just trying to get out each event that is a subject of the claim. And also they'll sometimes ask for information about damages, which will also be included on that. So when we're completing it, it's usually 1, maybe 2 pages, but I have definitely seen employees who have long 10, 20 page descriptions of what's happened to them because so much has happened to them. I don't think that's necessarily bad because you can make sure that if it's included in there, you've shown that you have raised that as a claim later on. But obviously, it's always better to not be too repetitive or to get into too much of the weeds that will be more relevant later in the affidavit stage.
And so at this stage, it sounds like so you're not attaching affidavits, you're not attaching supporting material. This is just what happened.
Yes. So this is just the formal complaint form that initiates the investigation. So once you submit that formal complaint form, the agency has an obligation to conduct an investigation into your claims, generally within 180 days. However, if you submit amendments, which I'll get to in a bit, that can extend the time frame. And in terms of the investigation, what they're going to do is first they're going to send you documentation and communicate with you about what they call the acceptance of claims. And that would be what I just mentioned, the format that we usually put it in. So it wouldn't be describing, for instance, if you're in a discriminatory meeting, it wouldn't be a long paragraph description of that meeting. It would be, on this date, she unreasonably accused me of XYZ or issued me a performance appraisal that had negative information. So just a very sentence summary of each instance. And so that would be the acceptance of claims that the agency will prepare and send to you. And it's important that you read that carefully because within that acceptance of claims, the agency will set forth if you have any objections to our articulation of the claims, the way that we worded the claims, then make sure that you notify us within, usually it's 5 days, but every agency, it's a little bit different. And so you will have to file a response if you disagree with them having dismissed some of your claims, or usually I find that a lot of the time the investigator will rephrase the claims to minimize the severity of the allegation. And so I tend to file objection letters, not just when claims are discriminated against, but also when I believe that the agency's articulation of the claims is inaccurate, misleading, or excludes in essential context.
So the investigator, it sounds like, is not really, I mean, they're not an opposing counsel. They're not adverse, but they're not necessarily there to help you. It sounds like they're there to protect the agency. And so you've got to be, I imagine, whether you're with an attorney or on your own, careful, like you said, with how they how they've framed the issue, because it might not be to your advantage, and that might be intentional on their part.
Well, I'd be reticent to go that far in that, I mean, legally they're required to have an independent investigator. And a lot of the time they are contracted by the agency. So they are independent contractors. But I don't know. I wouldn't want to speculate as to whether it's training or what it is, but it's just in my experience a lot of the time when claims are rephrased, and actually I can't think of an alternate example. They when they're reframed, it's usually to minimize the severity of the actions.
Yeah, it just maybe just inadvertence. I mean, you don't really know who. I mean, this is like you said, you could be contracted out to somebody, and you don't know their competence level. So it may be inadvertent. They're not trying to hurt you, but they're not necessarily an advocate for you either.
Absolutely. And I think that's essential to keep in mind because, I mean, there will be a lot of conversations, potentially if you are proceeding pro se, where they can advise you, and you just want to make sure you don't drop things just because of a verbal conversation. I have come into cases later on where clients have said, you know what, he told me not to put this in here. And I've thought, well, I'm not sure that was the best advice. So you just want to make sure you're a strong advocate for yourself, or that you have a strong advocate.
So once this process is complete, then what happens next?
After the acceptance letter is issued and you send them a letter, email saying what your objections are, if you do, the agency will issue a response where they will either accept your requests and reissue their statement of the claims in accordance with your requests, or they will just say, you know what, we stand by our dismissal, and essentially you can later raise that with the administrative judge. One of the reasons to make sure you file that objection is because later, if you get to the EEOC, if you haven't filed an objection, the EEOC is going to be less likely to revise your claims in the way that you think they should be revised. I mean, the agency does have final say, so all you can do is note your objection if they refuse to amend the claim, the articulation of the claims. But once they have the claims, an investigator will conduct an investigation. And that will start out by submitting or by interviewing the complainant. Now, generally, so some agencies, they will send you out a written questionnaire. They'll send you a long list of questions that they want you to answer, and you can provide the responses. Other agencies do prefer that the interview be verbal, and I generally prefer written because it gives you more control over the outcome. And usually when it's a verbal conversation, their write-up isn't even done with a court reporter. It's just their notes about your conversation, which always makes me nervous. I would much prefer to have something written where you can review it, read it, make sure it accurately reflects what your testimony is, and sign it. And a lot of the time, if the investigator does say, hey, I want to have this meeting where I ask you questions and we go through your affidavit, you can ask for a written version. And sometimes they will comply with that request and they'll send you over the written questions, and you can do it that way. Some agencies do stand firm on that, and they will have only verbal interviews, which is fine. It just, you have to be more careful in what you say.
Yeah, that makes sense. So it sounds like if you are going to do it verbally, that take your own notes, right? Because you may or may not get an investigator who's getting everything down correctly. I just want to back up just real quickly to the objections, to the framing of the issues by the investigator or by the agency. Is there a particular format for how you file those or how you present those objections? Just an email, or how does that get done?
There's no required format. I mean, usually we'll have a letter that includes case law, justifications, legal support, but it's not necessary. You can even just send an email to the email address that they say is acceptable. Sometimes if they only give you a mail address, a snail mail address, then maybe that's the way you have to do it. But generally you'll be able to even just send an email.
Got it. So once you file those, then they've interviewed you, or they've interviewed the complainant. So what happens after that?
So after you complete your interview and you submit your affidavit testimony to the investigator will then interview a number of individuals. Now, the investigator does have the leeway to select who they will interview, although the responsible management officials are always supposed to be interviewed. And we use RMO often. And what that means is the individuals who you are alleging discriminated or retaliated against you. And so the investigator will interview the RMOs and any other witnesses they think are appropriate. One thing I would always suggest is sometimes the agency will ask you to provide a list of potential witnesses. If not, I always like to include that in the affidavit or in my correspondence with the investigator, because it can always help if you can get a good witness interviewed in the investigation. And there's several reasons why it's better. For instance, sometimes you can always get a statement from someone who's willing to help you. But a lot of the time I find employees who would be witnesses are afraid to give voluntary statements because they don't want to be retaliated against themselves. And therefore, it can give those witnesses a little protection because they are required to participate in any investigation. And so if the investigator reaches out to them, requests their affidavits, then they have to cooperate. And so if someone comes back and says, well, why are you helping the complainant? Then that witness has a little bit of protection by saying, well, I mean, I had to write this. I had to write everything truthfully as I saw it. So that's one reason why it can be helpful to get the investigator to obtain statements of individuals.
Yeah. And we see that like in all of our cases, right? Like you have a buddy at work, or you think somebody that's got your back. And then when it comes to push comes to shove in litigation, they're, of course, as we all are, worried about feeding their family and paying their mortgage. And a lot of times the victim will lose out because all of a sudden they're not willing to stick their neck out. Even though, as you say, if somebody contacted them and asked them like what happened, they would be truthful. They don't want to, or unwilling to risk, or perceived risk their own career by coming forward. So to take that responsibility away from them, like we see this in all kinds of cases in court. Like if somebody is subpoenaed to be there, we see this all the time, right? Like I have a choice. Like I was subpoenaed to be here. And so I think that makes a lot of sense that if you can give them that out, like, hey, the investigator contacted me, I didn't have a choice, then you're going to get you're going to get that evidence that you need. Whereas if you rely on them to come forward on their own, that may or may not happen.
Absolutely.
All right. So what happens after that?
So after the investigator reaches out to the witnesses, including the RMOs, the investigator will then provide you, the complainant, with either a copy of the RMO's affidavits, their sworn testimony, or a summary of what their explanation for a certain action is. And you will then have an opportunity to submit a rebuttal statement. Now, a rebuttal statement is not required, unlike a lot of this process, and it's only optional. And I really wouldn't suggest submitting one unless you have new information to include. And so that would usually be if your supervisor is providing an explanation for something that you've never heard of before, if they're saying something for the first time, and you've never had the chance to provide your response to whatever that statement is in the past, then you can include it in the rebuttal statement. And you can also attach documents, both to the affidavit, I forgot to mention earlier, and to your rebuttal statement. So if you have a document proving that your supervisor didn't say the thing that they're saying in their affidavit, you can absolutely provide a copy of that email, and you should. So that's the purpose of the rebuttal statement. And that's really going to be the conclusion of the investigation period as far as you're concerned, until you get a copy of the report of investigation or the ROI from the investigator.
And these can be quite lengthy, right? I mean, like it's like a book.
Absolutely. Report of investigation, I mean, I've seen on the low end maybe 100 or 200 pages, but on the high end, I've seen ROIs that are 2,000 pages.
Good grief.
They can get pretty long.
And then so you get the ROI. What happens after that?
So after you receive the ROI, you should get a letter with that ROI, and you will then have 30 days within which you can either file an EEOC hearing request, or you can request a final agency decision, or of course, agree to dismiss your case, which I can't imagine a circumstance you would need to. But those two options, what the final agency decision is essentially you're asking the agency to make a determination whether it discriminated against you. I'm sure you can imagine the agency doesn't frequently find that it discriminated against someone. So usually the final agency decisions are going to be adverse. They're going to find no fault with the agency. And it's not the route that I would suggest unless you want to go straight to federal court. That'll get you there faster.
So we've got to the end of the formal complaint process, right? Like the next step, as you said, you can, ask for an agency determination or for an EEOC hearing. Is that right?
Yes. And the agency determination is just usually called a final agency decision, or FAD.
And the FAD, we'll talk about this more in the next episode, but really you're asking the fox to guard the hen house when you're asking the agency to determine whether or not they got it right. But we'll get to that in the next our next episode. So it sounds like for this stage, primarily the objective is to build your record. To build what happened, to get you, like you said, the claims delineated and set out, to get all your testimony in, your documents where necessary. I mean, you're not going to get a successful resolution. They're not going to come back and be like, "Oh, you know what? We screwed up. You're right." I mean, this is just setting the stage. The springboard for the next stage. Is that right?
Absolutely. And in fact, so the informal EEO complaint, the pre-complaint stage that we discussed last time, that has a specific setup that's meant to facilitate resolution. Once you get to the formal complaint stage, there isn't that at all. There's not really even an easy way to engage in settlement discussions because usually agency attorneys aren't even involved in this stage at all. So even as an attorney, we'd have to figure out who is representing the agency with regards to your case. And most of the time, they don't even know anything about the claims at that point. So it is really focused on developing the record. And you also, one thing I had forgotten to mention before is, if there are key documents in your case that you believe need to be included in the record, whether you have access to them or not, you should identify those to the investigator in your affidavit or in a call or communication, and that can help guide the investigator as to documents you think need to be included. Now, they again have full authority to include what they want to in the investigation, the ROI, but if you have a record of having asked for a certain documentation and then not providing them, it can help support a later argument that the ROI is deficient. So definitely make sure you would also include on your end any documents that you have in your possession that support your claims.
And then do you want to circle back now and talk about what to do when an agency doesn't do their part and finish the investigation on time?
Absolutely. So the agency is required to complete the ROI within 180 days of when you file the formal complaint. However, if you do file an amendment, and what that means is after you file the complaint, all of a sudden your supervisor suspends you or does this additional act of discrimination. And so you want to include that in the complaint. So what you would do is reach out to generally the EEO manager, but the investigator can certainly put you in touch with the appropriate person and ask them to include this additional claim in your complaint. And they will either include it as an amendment to your complaint, or tell you we're not going to include it. You have to file a new pre-complaint about that issue. And assuming they do include it, any amendment would more or less restart that clock. So they would then have 180 days from the date that you filed the amendment to complete their investigation. However, if you make multiple amendments or if you do the amendments very late in the investigation, the standard is that they have either the earlier of 180 days after the filing of the last amendment or 360 days after the filing of the original complaint. So what that means is if there are multiple amendments, they can't keep pushing back the deadline indefinitely. It still has to be completed within 360 days of the date that you filed your original formal complaint.
So you're looking at, as somebody going through this, at least 6 months and possibly as close to a year before you get the ROI.
Yes, that's correct. And while agencies are supposed to submit it within those timeframes, there's very little stick involved if they don't. So oftentimes agencies do they just don't complete it within the time period delineated. They also, sometimes they'll wait until the very last minute and then they'll say, we need your 80-page affidavit in the next 3 days. And that's unfortunate. I mean, I think the most important thing in that situation is you respond the best you can and say, I need more time. This is unreasonable. I have all these other obligations. So sometimes agencies will wait until the last minute to reach out to someone about their affidavit. And it puts you in an unfortunate position if they're waiting until the 170th day and then they say, we need your affidavit within 2 days. And it's a very long affidavit. What you would want to do in that situation, because I have seen it happen, is just make sure you record that you're doing everything within your power to cooperate and that you outline the unreasonableness of the request. So I can get it to you within 5 days, but I'm out of town or I've been sick. I'm doing the best I can, but 2 days isn't enough because I work from during these hours. So you would want to make sure you have that record so that if they try to say that you did anything wrong, that you can respond to that. And if they also then end up missing the deadline, you can actually file an EEOC hearing request within 30 days of the end of the investigation period, even if there is no ROI. And so that's important to keep in mind, because if they're very late, sometimes you might just want to wait until you get the ROI and then file the hearing request. But I tend to think that the strategically best decision is on day 180, unless they've reached out to you and said, we're going to send you the ROI in a couple days and it's clear you're going to get it shortly. I like to file an EEOC hearing request right away. And then I if assuming their ROI isn't shortly forthcoming, file a motion for sanctions against the agency, because there is very little recourse for the agency. There's not much recourse for if the agency is dilatory in its investigation, but that's the one way in which you can use it to your benefit. So it used to be, I'd say maybe 10 years ago or even less, I would see that administrative judges would almost never sanction the agency for late ROIs. But I think things got to such a degree, and there are a couple agencies, which I won't name names, that were just so dilatory with regards to getting the ROI out that, I mean, it would be a year late or more. And so administrative judges, yeah, it's a lot, I've noticed, and again, anecdotal, I don't know what the statistics would say about it, but I've noticed that administrative judges tend to are starting to issue more sanctions against agencies for failing to comply with that period. And I don't know if you think we should discuss that more in the EEOC hearing state podcast, but or if you want to go into the motion for sanctions now. But
Yeah, let's
I
do it.
do
We'll do
think
it
it's
at the EEO stage. I think that'll be a good place to talk about that issue. So let me ask you this. So in terms of like time frame and attorney's fees, so we're looking at 6 months, close to a year, depending how long the agency takes, possibly longer if the agency doesn't do what they're supposed to do. And I know we're talking ballpark here and it can vary widely, but as like kind of, what would you say kind of general ranges of attorney's fees if you hire an attorney to go through this process?
I mean, I think that it can be something that can be completed in as little as $20,000 of attorney's fees. It can also be more like 40,000. It varies depending on the number of claims at issue, the amount of objections you have to make, and the number of questions the investigator has. If it's a simple issue, then it's something that maybe you could get completed in $10,000 to $20,000. If it's more complicated, and I'll have a lot of times when clients have 20 claims outlined, and so that's where it gets to be. You get 80, 90, even 100-page affidavits that the client has to help you work on, and you have to review and revise as appropriate. And so that's where it can get in the higher end.
Yeah. So it sounds like, clients need to be prepared to, except in unusual cases, spend around $20,000 or possibly more. And this is not a stage at which you're going to settle the case. Unlike the informal EEO stage, where, however limited, there is some possibility you could get the case resolved in mediation. But in this formal complaint stage, this is all just about building your case to get to the EEOC. And so you got to be prepared to spend that money. You can, and correct me if I'm wrong, but then there are going to be opportunities to settle, in the EEO stage EEOC stage without going through the entire litigation process, although that's always a possibility. So there are going to be those opportunities there, and there can be opportunities to get your attorney's fees paid. But I think it's important for folks to know they're looking at that outlay again over the course of 6 months to a year. So it's not like it's going to happen all in one rush. But you got to be prepared to spend that, to get the advocacy that's going to put you in the strongest spot. And you're not, except in very unusual stages, you're not going to get this case settled at this stage.
Well, and one thing to keep in mind too is that these attorney's fees are recoverable if you, again, succeed down the road. The attorney's fees expended in the EEO formal complaint stage, if you succeed at proving discrimination, you will be able to get the agency to pay for those. Technically, at the informal stage, that's not the case, and you cannot necessarily you aren't entitled to recovery of attorney's fees expended at the informal stage. However, a lot of the time I find that agencies will negotiate to give you those fees back if you're coming to the table for a settlement.
Yeah. And you're talking about much smaller numbers there too than once you get later into the process. All right. Well, this has been very helpful. So now, just to kind of recap, we've gone, from the last episode talking about the informal EEO process. And now we're talking about the formal complaint process, stages, right? Stages along the railroad track where we're trying to get you to your destination. And some really great stuff here from you about, the strategy, about how to, setting forth the claims and getting those set and getting any objections you might have. And I think it's a good thing for folks to know that you're not dealing with attorneys at this point. You're dealing with agency employees who are, hearing officers and people who are, helping with the state, but this isn't where the agency is doing advocacy in the sense they're advocating against you, but it's really important because it sets the threshold for the next stage. Did I get all that right?
Absolutely. That's right.
Great. Well, Louise, thank you so much for joining me for this one. And next one, we will jump into the EEOC process and the FAD for those people, for the final agency decision, for those people that might want to choose that route. And we can talk about strategies for which way to go. But again, thanks for joining us and look forward to having you on next time.
Thank you. I appreciate it. And I also look forward to the next step.
Very good. Well, thank you for joining us on this episode of the Spiggle Law Firm podcast. If you'd like to get more of this kind of information, you can go to our site, thecareerrocket.io. You enter your email and you will weekly get the latest and greatest in employment law and other tips and tricks on how to keep your career on an upward trajectory. And as always, you can go to our firm website, spigglelaw.com. We have a lot of great information there. And we always appreciate it if you like this episode, that you share it with other people. We're trying to help as many people as possible realize their employment law rights at work. So if you know somebody in the federal sector who could use this, please send it their way. Thank you again. And until next time.